Hi, I'm Sharon Toerek, a marketing and intellectual property lawyer. I'm principal of Toerek Law, and I'm author of the Legal and Creative Agency Protection System. I've counseled independent marketing agencies nationwide for almost 15 years on their industry-specific legal issues, and I'm going to share some of what I've learned with you in a series of legal and creative law lessons. In today's legal and creative law lesson, we'll discuss top tips to protect your agency during the agency-client contract process, including the points your agency should always include in its client service agreements, and the points you always need to watch out for whenever a client presents its contract form to you. So you landed new business, and that's great, but now you'll need a services contract with the client. And first things first, you do need a written contract. You never want to move forward with the client project without it. So the best way to be prepared for this is to always have an agency master services agreement handy with all the important provisions that you need for the relationship. Here are some of them. First of all, a description of the type of the agency engagement, whether it's a retainer, a project only, or an agency of record relationship. Next, fees and payment policies. This is very important because you want to make sure you include language that protects the agency in the event of late or non-payment, including provisions like interest, late fees, and attorney fees for non-payment. Next, intellectual property ownership and transfer provisions. This is a point that it's always important to stress in your contract because you want to make sure that this intellectual property to the work doesn't transfer until the agency gets paid for its work. Next, portfolio display rights for the agency. This is also important because the agency always wants to maintain the flexibility to display its work for its promotional purposes, and you want to make sure you negotiate that into every client agreement. Next, restrictive covenants like confidentiality, non-solicitation, non-competition, or exclusivity. You want to make sure these are addressed so that the client doesn't directly hire your employees, your contractors, or cut the agency out of the relationship. Next, client responsibilities. You want to make sure the client is assuming responsibility in the contract to make approvals and decisions in a timely manner, that it appoints somebody who's got decision-making authority, and that it provides you accurate information to work with. Next, liability limitations and indemnifications. You want to make sure that you limit these as much as possible and only to the actions that are within the control of the agency. Things like intellectual property infringement for work created by the agency and ad claim accuracy for claims that are made by agencies. Many times agencies, again, are presented with the client's contract form. My preference is always for agencies to use their own master services agreement, but if you decide to review the client's form and use that instead, here's some points you'll want to look at and whenever possible negotiate out of the contract. First of all, it's inevitable that you will see work for hire language in the contract that will automatically transfer the rights to the work that you do for the client on creation of the work. You want to negotiate this provision out of the contract. You want to make sure that the rights to the work don't transfer until the agency gets paid. Next, restrictive covenants. You want to make sure that you negotiate out things like category exclusivity out of the agreement so that the agency has the flexibility to pursue as much other business as it needs and wants to. Next, payment terms. You want to reduce the payment terms to as short a period as possible. The industry trend right now is obviously to stretch these out as long as they possibly can. You want to keep it to 30 days whenever possible and to negotiate yourself away from those 60 and 120-day terms. Next, liability limitations and indemnity. You want to limit this provision to conduct that's reckless or intentional or knowing on the part of the agency and exclude any liability for conduct or claims or information provided by the client. Insurance requirements. You want to make sure that the policy limits that are set forth in the contract match the policy limits that the agency has in place and that you're reviewing this on a regular basis to make sure you're in line with what the agreement says. I'm Sharon Toerek. I hope you found this information helpful. And if you'd like more legal tips and tools for your marketing agency, visit agencylegalprotection.com. Thanks for watching.